I am going to do my best to briefly break down all of the juicy details from yesterday's mediation for you, but I can tell you already it's going to take me a few videos. So first of all, you have to understand it's a divorce. There were no minor kids, but there were some pretty significant assets, mostly tied up though in a house. So the house had equity of, let's say, like $500,000. And then there were some other little things like cars and personal items and stuff. The husband had an attorney who's a good attorney, was very well prepared herself from the information that she was provided before mediation. And the wife did not have an attorney. That takes a little bit of time to process. They're separated. They've kind of never really lived together. It's a whole complicated situation. The wife obviously is having some feelings about it. Once she accepts that the divorce is going to happen, so we can either do it through an agreement, or if we can't reach an agreement, you're going to go in front of the judge, and the judge is going to make the decision. The decisions that have to be made right now are really equitable distribution, because that's the only thing that's on the table. At that point in time, I told the wife what the husband wanted to do, that she could refinance the house, get the $250,000 out, pay him off, take his name off the mortgage. He would keep his debt. She was in shock. This is not what we talked about beforehand. We've talked before. He's always told me I could just keep the house. That brings us to the next point, that whatever it is that you guys have talked about before or agreed upon verbally before, or you thought you were clear on, I cannot tell you how many times people come into mediation with this kind of concept. You really just need to leave it at the door, because if nothing was signed, nothing was agreed on. A lot of times people off the record or in casual convo or something make these kinds of agreements, then they talk to their lawyer. Now that's not the option anymore. So we kind of get past the whole situation of we're not going to get a divorce. Then we kind of get past the whole situation of we're not going to do what you thought we were going to do. What's next up? And this is where I want to say to you guys, I was so impressed with this pro se party, this unrepresented wife. So I explained to her the concept of equitable distribution, right? That we have to look at all of the assets and all of the debts that are marital, meaning they were incurred or acquired from the day you were married until either the date of separation or the date of filing. And then we've got to figure out how to divide all of that up equally, right? So that you get the same amount of assets and the same amount of debts as one another. And I explained to her that he was offering to keep his own debt and split the house. And so therefore it really was a credit to her. It was to her benefit. And she at that point said, well, if we're going to talk about debts, let's talk about mine. Which brings me to the next point. She didn't list any of these debts on her financial affidavit, which was the big problem for the lawyer in the other room, because the lawyer had absolutely no idea that these debts existed because they weren't produced in discovery and they weren't listed on the financial affidavit. In her mind, she's like, why does it matter? Because we're just going to walk away. So at that point in time, we have to take a break from mediation, give her a few minutes to go get proof of these debts, because when I say debts, I'm not talking just a little bit of debts. I'm talking $200,000 in IRS debt, $150,000 in student loan debt that was taken out in her name for the child's sake, and about $50,000 in credit card debt. Which brings me to the next point. The husband claimed credit card debt as well, and she was claiming credit card debt. However, all of that credit card debt had already been charged off. So it showed up on their credit reports, which is always a good thing to pull. And I had told this mom, go pull your credit report while we're sitting here so we can see it. Even though it shows up on the credit report, it's not actually payable debt. So that was a whole other conversation. But $200,000 in IRS debt, $150,000 in student loan debt, $350,000 in debt in this woman's name that she basically is on the hook for in terms of who the lender, but in terms of the marriage, they're both on the hook for. So that means that half of that, $175,000, he's going to owe to her. So now we got to start doing the math on the equity of the house, taking that into consideration. And in the end, what this woman won herself, once all of the math was done, basically, we came to the conclusion that what the wife wanted from the get-go was really to the husband's benefit, which was to just give her the house, take his name off the mortgage, and let her move on with her life with the house, for him to keep his debt and her keep her debt. At the end of the day, the husband actually probably got the better financial deal. The wife got what she wanted out of it, which was the house. Once an agreement is reached, what happened from there is what happens in every mediation where we fully settle, which is that we type up the settlement agreement and send it to both sides. Everybody made edits that they needed. We went back and forth a couple of rounds to get it where we needed it to be. And then I, as the mediator, send it out through Adobe Sign. Everybody signs off on it. That gets filed with the court along with a report from me that says we fully settled. And the case gets set for a final hearing, which some judges will let you waive if you just submit final judgments. Others make you go on motion calendar. It's a quick 5-minute hearing. You say the marriage is irretrievably broken. You've settled all issues. You show proof of residency. You're divorced.